allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Dear Father God, bless us as we gather here today. May you be present in the mouths of all who speak, in the ears of all who listen, and at the heart of all we say and do. We ask this in Jesus' name. Amen.
Chairman, Directors, the first item on your workshop is Hidalgo County Regional Mobility Board of Directors Annual Ethics and Compliance Training. Ms. Blakely Fernandez, our General Counsel, will be conducting the training this evening.
Hi, good evening.
Good evening.
Welcome to the annual Ethics and Compliance Training. I'm sorry that Rick's not here. I think this would have been his 10th training, so I guess he gets a pass for tonight. All right, so RMAs around the state of Texas are required to adopt and enforce an internal ethics and compliance program. This is designed to detect any violations of laws or regulations or ethical standards, enforce compliance with the program that we've established, institute monitoring and auditing systems, and then provide annual training like we have tonight. And so the employees are here as well as the board members for this training. We're going to cover these 7 areas of discussion. I'm going to go through things quickly, but we've got time to stop and take questions, or if I'm passing over something too briefly and you want to spend more time on it, just let me know. And with each of these areas, we're going to talk a little bit about state law. A lot of times there are TxDOT rules that are even more narrow than the state law, and then in some cases we've got policies that we've approved that are even a little more narrow. So our first area we're going to discuss is conflict of interest. The general conflict policy, if you've sat on other boards and commissions or been elected within the state, is a disclosure type of conflict. So this is a prohibition on participating in a vote or matter involving a business entity or property which an official has a substantial interest and would receive an economic benefit. If you have a situation like this as a board member, you shouldn't vote or deliberate on that topic, and you have an obligation to disclose it, and we'll review that form here in a little bit. I just want to highlight that the thresholds for substantial business and property interest are very low. It can be as low as $15,000 in fair market value for a business interest and $2,500 in value for a property interest. So it may not register with you as substantial, but that's the threshold that requires the disclosure and the recusal. TxDOT has adopted a series of rules to help protect RMAs, and they use these rules also internally from any real or perceived conflicts. And so as an RMA director or employee, you shouldn't accept or solicit any gift or favor or service that might influence your official duties. No employment or business or professional activity that might require or induce the disclosure of the RMA's confidential information. No employment or compensation that could impair independence of judgment. No personal investment. That would also include your spouses that could create a conflict with the RMA. No solicitation or acceptance of any benefit for the exercise of official duties. No performance of official duties in favor of another, and no personal interest in an RMA agreement. These are lists of prohibited conduct. They can be boiled down under the responsibility of the official into some broader categories. And these are things that TxDOT enforces very strictly internally and that we try to highlight in our training. No lunches, dinners, trips with vendors, anything that could be perceived to influence decisions. No sharing of RMA confidential information. That's something that's not yet public. The one that's always the most risk is future right-of-way or planning for projects. No purchase of land in or near projected right-of-way, and no interest in any RMA contracts. And then there are a certain level of conflicts that TxDOT has determined would make a board member ineligible for service, and these apply also to the executive director. So if you or your spouse are employed by, manage, or own a business or other organization that's regulated by TxDOT, the county, or the RMA that uses or receives a substantial amount of tangible goods, services, or funds from TxDOT, the county, or the RMA, or is required to register as a lobbyist. Those 3 items would make you ineligible for service. So your responsibility would be to not just disclose the potential conflict as in previous situations, but also to resign from your position. So we've got, in the compliance section of the conflict area, an annual certification that we do, and I think that's at your place. So this is a certification that we'll sign tonight. And then should you have one of those substantial business or property interest conflicts, there's a form that the state has created, the Form 171. That has to be filed within 7 days of becoming aware of the conflict. This would typically be in a situation where either you would have a business interest that might change with an existing vendor, or we would have a procurement out and there may be a potential contractor that may have a conflict. All right, our second area is bribery and gifts. Under state law, bribery is intentionally or knowingly soliciting, offering, or accepting a benefit in exchange for a decision, opinion, recommendation, vote, or other exercise of official discretion. And a violation of this statute is a second-degree felony. Oh, let me see. I'm missing a section there. There are exceptions to the bribery statute. And these are outlined in state law, but TxDOT has made some additional comments on those. So non-cash items, promotional items, things you might get at a conference or as part of a advertising promotion are considered exceptions to the bribery statute. TxDOT puts a cap of that at $25. So you're really talking about baseball caps and stress balls, t-shirts, those kinds of things. Food, lodging, and transportation is usually an exception to the bribery statute. TxDOT limits that to official business. If you're going to a state conference or you're going to speak as an RMA board member at a conference, that would be an exception to the statute where the conference can pay for you. But otherwise, they're pretty strict on restricting any food, lodging, and transportation benefits. Gifts from friends, relatives, business associates, those are considered exceptions to the bribery statute. If you have an existing relationship with someone, they've always given you a Christmas gift, you can continue to accept those kinds of gifts. And then any payment for legitimate consideration is an exception to the bribery statute. So something in the ordinary course of business may be a conflict for disclosure purposes, but it wouldn't constitute a bribery. Okay, the next area is use of government property. We typically think of issues related to government property and misuse. Those are phones, computers, software, email systems. That's where we see the most activity. That doesn't really apply to this board because you're not given any of those tools by the RMA other than you do have an email system. So what you want to be mindful of is information. That's the government property that you have the most access to here. So any type of use of information for future projects or future right-of-way could create the misuse of government property. All right, nepotism. This looks like a complicated slide. It's pretty easy for you all because as a board you hire one employee and that's the executive director. So you should not hire an executive director that you or your spouse is related to in any way. And if we come into a situation that's in this gray area, we can walk through it at that time, but that would be prohibited. All right, open government. I think you've all had your open government training that you do online through the Texas Attorney General, and it covers the Open Meetings Act. These are the basic constructs of that act. An open meeting is any meeting of a governmental body of a quorum that discusses that body's their official business. So you've got a board of 7. If there's 4 of you and you're discussing a project or any business of the RMA, then you likely have an open meeting, and that means it needs to be posted, it needs to have an agenda, you've got to have the 72 hours notice, except in very rare situations, or if we're in an official executive session. An open meeting, a public meeting, can occur not just at the traditional regular board meeting, it can occur at a public hearing. So if we've got a hearing on a project and more than 4 of you are going to be there, then we would want to post that as a public meeting. If you do a joint workshop with another governmental entity, with a city or a county, and there's going to be more than 4 of you there, and you're going to be discussing the RMA's business, we would need to post that for the public. Where it becomes tricky is with emails and text messages. If your email chains cover more than 4 of you on a topic, that may be a public meeting, and so you can have a violation of the Open Meetings Act just by emails or text messages. And then walking quorums. If you are having conversations that are daisy chained together, not with 4 of you in a room at one time, but with 2 here and 2 there, then you may have an open meeting that would require the agenda and the 72 hours notice. So walking quorums have been somewhat, I guess, confusing over the last year. In 2018, the Texas Supreme Court said that the state law wasn't specific enough to have the criminal enforcement component of the walking quorum. The legislature this last session made some modifications to the statute. They didn't really change the statute. It's the same concept that we've had, that if you're aware, if you're knowingly having conversations to avoid a quorum, but you are including the same number of members it would take to have a quorum, then you've got what they call a walking quorum. So with this state law addition, I think the issue of walking quorums is clear again. It's what we all assumed it was before 2018. And so you just want to be mindful that that it is a criminal offense to participate in a walking quorum. All right, there are exceptions to the open meetings requirement, and those are when we go into executive session. And we've got very specific authority for executive session, and only that specific authority, so we shouldn't ever go in for issues other than what's listed here. Typically when we go in, it's for consultation with an attorney, real property issue, or a personnel issue. But there are a few other authorized topics for closed session. And then you can bring in staff and other resources that need to be there. Who you can't bring in is third parties. If you've got an arm's length negotiation, there's vendors and others that will suggest, well, we could talk about all of this in closed session because you can talk about your contracts. That's not considered an appropriate party for a closed meeting. So with regard to open government, what's important for the board members to know is that the responsibility is really on you. It's not, doesn't fall to me, it doesn't fall to the staff. The criminal liability falls with you, and the responsibility to not participate in public meetings that are not properly posted falls purely with you. Public information, this is another training I believe you've done, all of you, with the Attorney General online already, so we'll cover this one quickly. But all the information that is collected by the RMA or its vendors belongs to the public. So if you think of if the public dollars have paid for it, it belongs to the public. There are some exceptions with regard to information that we have to release. We don't have to release draft material, attorney-client communications, certain third-party proprietary information if the third party doesn't want to release it. And then we've got exceptions for certain Homeland Security and technology network kinds of information. The Public Information Act doesn't distinguish whether the information is in your office, in my office, in a vendor's office, on your phone. The definition applies to the information, not to the device and not to the location. So if the public has paid for it, is an easy way to think about it, it belongs to the public. So a new law that was passed this session, which is in orange there, is the temporary custodian law. And that applies to board members. If you're getting information on your personal device, you're considered a temporary custodian of that information, and you need to email it to an official location. So whether that's your RMA email, or if you want to send things directly to Pharr or to Celia to keep, if you get any RMA business on your personal device, we need to create a public shadow record of it somehow in an official capacity so that it can be generated in the event that there's a request for that information. All right, the compliance program is our final piece. This is a standard TxDOT created several years ago now that RMAs are required to adopt and enforce their internal ethics and compliance program. We have done that, and this training is a part of that. We also have this button here you see on the bottom right, the fraud reporting button. That's on the website. It's been there for years now. That's a way that the public or an employee or anybody can make an anonymous notification of a potential fraud or a concern that they have. That reporting goes directly to Pharr and to me, or may go to Celia as well. But so we've got some checks and balances that multiple people see it when it's reported. We've got a full compliance program that then also covers these other areas on the left there, everything from record retention to gifts and honoraria. We've also adopted an internal bullying policy that's been included in the compliance. And there are annual certifications that are required to TxDOT as part of our compliance program. You've got the certificates that I mentioned earlier that we'll sign tonight. And that shows that you've been through the training. It gives you an opportunity to declare any conflicts or issues that need to be disclosed so that we can address those properly. And then we have other training evidence that the RMA collects and retains for board members, your open meetings certificates, your PIA training certificates. We've got certain members of the team that will have been to the Public Investment Act training. We keep those certificates on site, and other training that TxDOT requires. On the right is the list of reports that the RMA is required to file. Most of those are on an annual basis, not all of them, but everything from the strategic plan to your annual audits, investment reports. The new report that was added this session is a toll entity financial report. Since we don't have a toll project off the ground, we won't have to do that this year. But there's a pretty extensive list of reports, and Celia and Pharr do a good job of making sure that we've got those all filed timely. And the final thing is that we keep an updated ethic and compliance handbook. So you've got a flash drive that has all of the information outlined in this title page here provided there. This will also be on the website. So if you've got a question later or there's something you want to look up, it's a searchable document on the website that you can access it from there without having to find the flash drive or keep track of a cumbersome notebook. And that's it, unless you have any questions.
Thank you, Blakely.
Okay, thanks.
What is that?
Great, Pilar. Thank you.
Chairman, the next item on your agenda is public comment. I do not believe we have anyone signed up for public comment.
Okay, if there's no public comment, let's go ahead and go to open reports.
The item 1A is reports on program manager activity for the 365 Tollway project and the IBTC environmental clearance document. Eric Davila will give you a brief update.
Good evening. Direct your attention to slide number 4. Essentially, we've had, since last month's meeting, we have a 2020 UTP debrief that we wanted to cover. Essentially, like the Transportation Commission said, the work for 2021 UTP started at the last commission meeting, and I think we should take that directive as our cue to start to line up the 2021 UTP push, which continues to be the 365 toll project, seeing through the project development agreement updates that are necessary for lining up the rebid of the project or potential new funds for the project. The IBTC is also listed. It's not currently in the 2020 UTP. It ought to be in the 2021 UTP should we want to start attaching strategic funds or other TxDOT funding that, as we all saw, is largely available and untapped yet. We should always just keep this project at the top of the list so that we're all talking off the same sheet of music with stakeholders, the state, reps that might be asking and pulling us to the side for information on the project. Everybody's going to have the same sort of script on where we are with these various projects. Our meetings with TxDOT these days start off with where's the last correspondence been, who's got the ball in court, who owes who what, so that moving forward, if anybody gets asked that question, where are we on the project, anybody at any level could say, this is where we are in the environmental, this is where we are on traffic, for instance, on IBTC, or for 365. Like, for instance, we have some comments that are supposed to make their way back to us on how we proceed with the project development agreement conversation this week. So those are the kind of things that we're gonna be showcasing and talking about a little more, so that we're all on that same level of information and hold ourselves accountable, like I know TxDOT holds themselves accountable. The second point is what's on the RGV MPO local plan. As y'all are well aware, the project planning goes from the local level, the stakeholder level. In this case, now we have an RGV MPO. The last actual MPO meeting for Hidalgo County is this week. From here on out, it's RGV. We're regionalized. So what does that mean? That means that a lot of the carryover from the Hidalgo County planning has made its way to RGV MPO. And late this year, early the next, we're gonna start planning the next round of plan updates. Those plan updates become important. And that's why having where we are in each particular project becomes all the more important as we have these discussions about what becomes the priority, who's more ready, who's ready for additional funding, who's ready with environmental. All those become very important questions in those discussions. And so we're gonna have a lot of that information called out to the forefront from reports from here on out. And then so essentially moving forward is to have this information available. And again, I'll start off every report from here on out that'll cover where we are in each particular project so that we can essentially secure the financial commitments and move the projects forward. There's a lot of project information in the rest of the report. I'd be happy to go through any particular project if y'all should have any questions.
I think we're fine, Eric. Any quick questions from anybody?
No? All right, well, thank you all.
Thank you very much.
Chairman and Directors, I do want to add that last week we did meet with TxDOT staff to discuss the next steps on our financial commitments, and the direction we were given was that we need to update our project development agreement for both 365 and IBTC, our financial assistance agreement for the 365 project, and the state infrastructure bank loan agreement for the 365 project. So we are supposed to get comments back this week to give us a more definitive direction on each of those instruments. Chairman and Directors, the next item on your agenda is the consent agenda. All matters listed under the consent agenda are considered to be routine by the governing body and will be enacted by one motion. There will be no separate discussions of these items. However, if discussion is desired, that item or items will be removed from the consent agenda and will be considered separately.
Can I get a motion for approval of the consent agenda?
Second.
Motion in favor, all those in favor say aye.
Aye.
Opposed, same sign. Motion carries.
Chairman, Directors, we have no further business for your consideration today.
Can I get a motion to adjourn?
So moved. Second.
Motion second, all those in favor say aye.
Aye.
Opposed, same sign. Motion carries.